Hello, law students and legal practitioners. Today, we will analyze the case of Kilosbayan, Inc. vs. COMELEC, GR number 128054, decided by the Supreme Court on October 16, 1997. Let's begin. Here are the legal doctrines of the case. The Commission on Elections, COMELEC, has the exclusive constitutional and statutory authority to investigate and prosecute election offenses, but such authority is not absolute and must always be exercised, where appropriate, meaning only when probable cause is sufficiently established. Probable cause exists when the facts and circumstances would lead a reasonably prudent person to believe that an election offense has been committed. This determination must be based on competent evidence, not mere suspicion, speculation, conjecture, or hearsay. A private complainant bears the burden of proving probable cause by submitting affidavits and supporting evidence. The COMELEC is not duty-bound to search for evidence on behalf of the complainant, nor is preliminary investigation a venue to fish for proof. While the COMELEC may independently verify evidence, its role is adjudicative and evaluative, not investigative in the sense of acting as the complainant's agent. Newspaper articles and media reports are hearsay evidence and have no probative value unless corroborated by admissible evidence. Circumstantial evidence may establish probable cause only if each circumstance is proven by competent evidence and forms an unbroken chain leading to guilt. Finally, grave abuse of discretion arises only when an act is capricious, arbitrary, or despotic and done without regard to law or evidence. The dismissal of an election complaint for insufficiency of evidence does not constitute grave abuse, especially when the complainant failed to meet the minimum evidentiary threshold required by law. Here are the relevant facts of the case. The case arose from a complaint filed by Kilosbayan, Inc., alleging that public funds from the Countrywide Development Fund, CDF, under Republic Act No. 7180, GAA of 1992, were illegally released shortly before the May 11, 1992 elections and used for electioneering purposes. Specifically, 70 million pesos was released by the Department of Budget and Management, DBM, to the Department of Interior and Local Government NCR, DILG NCR, and subsequently transferred to the Philippine Youth, Health and Sports Development Foundation, Inc. PYHSDFI, an accredited NGO chaired by Ronaldo Puno. The release was made pursuant to presidential authorization allowing DILG to implement CDF projects through NGOs. The PYHSDFI used the funds for sports, health, and cultural programs in Metro Manila. Kilosbayan alleged that PYHSDFI acted as a conduit for the so-called Sulo hotel operation, which supposedly financed election campaigns using public funds. In support of its complaint, Kilosbayan relied primarily on newspaper columns, excerpts from congressional and Senate hearings, and an affidavit by a political candidate claiming overheard conversations about campaign financing. The Commission on Audit, COA, conducted a special audit and found accounting deficiencies but no proof of electioneering. After a lengthy preliminary investigation, the COMELEC Law Department and N-Bank dismissed the complaint, finding no probable cause. The dismissal was affirmed despite multiple motions for reconsideration. Kilosbayan then filed a petition for certiorari, claiming grave abuse of discretion by the COMELEC. Issue 1. Whether the COMELEC committed grave abuse of discretion in dismissing the election offense complaint for lack of probable cause. No, the COMELEC did not commit grave abuse of discretion. Under Article 9C, Section 2, 7, of the 1987 Constitution and Section 265 of the Omnibus Election Code, COMELEC prosecutes election offenses only when appropriate, meaning when probable cause exists. Probable cause must be supported by substantial, competent evidence, not hearsay or speculative allegations. The complainant bears the burden of proof. COMELEC conducted a full preliminary investigation, issued subpoenas, received counter-affidavits, examined COA reports, and evaluated all submitted materials. The dismissal was based on reasoned findings that no admissible evidence established electioneering, misuse of public funds, or conspiracy. The exercise of discretion was lawful and evidence-based, not arbitrary. Issue 2. Whether COMELEC was constitutionally required to gather evidence for Kilosbayan. No, the COMELEC had no such obligation. COMELEC rules of procedure require that a complaint be verified and supported by affidavits and evidence. Preliminary investigation is a probable cause determination, not an evidence-gathering expedition for the complainant. Criminal prosecution cannot proceed without the complainant satisfying the burden of proof. Kilosbayan initiated the complaint, participated as a private complainant, and repeatedly failed to supply competent evidence beyond newspaper articles. COMELEC even undertook additional verification despite this failure. The law does not compel COMELEC to build the complainant's case. Issue 3. Whether the release and disbursement of 70 million pesos constituted an election offense. No, the release did not violate election laws. To violate Section 261, O, V, or W, of the Omnibus Election Code, the prosecution must prove use of public funds for election campaign or disbursement within the prohibited period for public works, and absence of statutory exceptions. The funds were released pursuant to lawful authority, used for NGO-implemented social programs, and not for public works or campaign activity. COA findings revealed administrative deficiencies but no evidence of partisan use. Timing alone does not establish criminal liability. Issue 4. Whether hearsay evidence can establish probable cause in election offense cases. No, hearsay evidence cannot establish probable cause. Newspaper articles are inadmissible hearsay and have no evidentiary weight unless corroborated. Probable cause requires more than suspicion. Kilosbayan relied heavily on newspaper columns alleging the existence of the Sulo Hotel operation. No witness testimony, receipts, distribution lists, or proof of campaign influence was presented. Without competent corroboration, COMELEC correctly disregarded the hearsay evidence. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.